That around the 27th of December, the President of South Africa issued an application for an urgent interdict.
When you say the private prosecution was issued in December, I take it that it's some...
The summons, that's correct, madam.
Yes, but it's not against the current president.
No, it was against Mr. Ramaphosa as a person, but that's a debate for another day. It was issued on the 15th, my lord. I don't know if your lordship has got the face. We gave the... Maybe I can just, for the sake of reference, your lordship can just have it. Thank you, madam. So your lordship will see on the face of that it says it's issued on the 15th of December, and it says in the matter between Mr. Zuma and Mr. Ramaphosa as the accused. Then on the 27th, my lord, the President of South Africa issued separate proceedings in the civil court, which your lordship would know on Monday was a judgment around that. The legal effect, at least one of the legal effects of that was the fact that the accused is not here today. His interpretation of that order is that he's exempted from appearing today. We have a different interpretation, but that's not a matter that your lordship has to worry about for today. So, my lord, in terms of Section 11 of the CPA, and I know your lordship doesn't have time, but just for the sake of perspective, I'll just read it out quickly. 11.1 says, my lord, if the private prosecutor does not appear on the day set down for the appearance of the accused, it says in the magistrate court, but that's been interpreted to mean in any court, or for the trial of the accused, the charge against the accused shall be dismissed unless the court has reason to believe that the private prosecutor was prevented from being present by circumstances beyond his control, in which event the court may adjourn the case to a later date. So it's that last part that really brings us before your lordship, for the court to adjourn or postpone the case to a later date. For the sake of completion, I'd read subsection 2, my lord. It says, where the charge is so dismissed, the accused shall forthwith be discharged from custody and may not in respect of that charge be prosecuted privately again. But the Attorney General, and that means the NPA, or a public prosecutor, with the consent of the Attorney General, may, at the instance of the state, prosecute the accused in respect of that charge. In a nutshell, without this sitting, the charge would be dismissed. And that situation is more serious, my lord, as you know, than what would happen in the civil courts, where the matter may be struck off the roll, then you can re-enroll it. Here, the wording is very clear. It will be dismissed, and you can't bring it back unless if the NPA chose to prosecute. So this appearance is important for that reason.
So it's to keep the proceedings extant.
Absolutely, my lord.
That is the whole purpose.
Absolutely, that's the whole point. Yes.
Right.
So that it's otherwise you can't even take the risk of a striking off, which you rather striking off the roll, which you could cure. This time it would be incurable. That's correct, my lord. Now, moving away from that, then, my lord. Our instructions that we have are to appeal the order that was given on Monday.
The full bench.
The full bench order. Albeit we know it's an interim order, your lordship knows the law, exceptional circumstances and so on. We have not yet decided which court to approach. If, as we are inclined to do, it goes directly to the Constitutional Court, then we'll seek leave from that court. Of course, if we want to go to the SCA, then we must seek leave from the full court itself. But we have 15 days to make those decisions. So but in principle, there will be that appeal. Now, so that's for perspective. The third thing, my lord, that I need to appraise you of is that in terms of the order, And my Lord, again, I know that you file, but just for your Lordship's own edification, not for now, I'd beg leave to hand up the judgment that was issued on Monday.
Thank you.
If your Lordship goes to typed page 15, which is the last page of that order.
Yes.
The Lordship will see the following. The court ordered, I quote, the parties' representatives are directed to immediately approach the office of the Deputy Judge President Johannesburg to arrange a case management meeting to set an agreed date for the hearing of Part B.
Yes.
Why I'm bringing that to your Lordship's attention is for the following reason. In the civil court process, Part A, Part B, and so on, that meeting took place yesterday as duly ordered. And an agreement was reached between the parties in that matter to hear that matter on the 17th and 18th of May, 2023. Thank you. My Lord, sorry if I may interrupt myself. I forgot to mention that in this matter I appear with my learned friends, Ms. Mshololo and Mr. Tlachwayo, as the representing the private prosecutor.
Yes.
My Lord, may I just take that opportunity to confirm my attendance, my appearance on a watching brief for the accused, Mr. Ramaphosa.
And your name is, madam?
Umzile Sokela from the Johannesburg Bar.
Thank you, Ms. Okela. Yes, Mr.
Thank you, my Lord. So I was then saying so that matter is now has a fixed date. It will be heard in due course. But it's my duty to bring to your Lordship's attention that the order that was obtained at paragraph 2, still on page 15, says pending the final determination of Part B.
Yes.
Yes, so your Lordship knows what that means. That then means including appeals. It's not like the outcome of just the hearing,
yes,
which is going to be here, including appeals right up to the Constitutional Court. And that's one of the reasons of the issues we'll raise in the appeal. That is over wide, is too broad, whatever. We don't have to bore your Lordship with all those. So then given all these three things that I've mapped out, then, my Lord, it is in our respectful submission, we would like this court. Sorry, my Lord, I just want to make sure that I'm not. Yes, I've covered everything. So we come to the business of today. It is that then, my Lord, pending all whatever developments might happen, obviously we will have to report to this court as the criminal court at the next hearing. All sorts of things might have happened. High road, the appeal, the interim interdict might be reversed or confirmed. Part B would have been heard. We know that the court is usually not inclined to give a long postponement, but we beg the court's indulgence so that we don't come up and down here.
Yes.
And that's why we've put the date after the hearing of
17th, 18th.
On 18th. That's correct, my Lord. So that all the questions by then would have been answered. Is the interpretation of the order that it entitles the accused not to be here correct or not correct? We will debate that with the other side. Is he indeed exempted? Is the order by the interim court correct or not correct? All those may be hopefully resolved by then, and we will report to that court of progress, if any, there might be no progress. And that is why Your Lordship mentioned this in chambers. That's why in criminal matters, the law is very clear that matters don't get adjourned sine die, because the court has a duty to keep the supervision. This court now, the criminal court, has a duty to supervise the matter. Otherwise, trials can be delayed forever, and run into the atmosphere. So that will be our duty to that next court, my Lord. Having met that background, my Lord, and I'm indebted to Your Lordship for listening to that background, we have then prepared a draft order. My learned friend, Ms. Sokela, has made it clear that they are here on a watching brief, so they are watching. And
she's privy to the order.
She's privy to the order, certainly, my Lord. In fact, yeah, she is more than privy. She assisted us in even drafting it. But that was just collegiality. I don't want her to be in trouble with her clients. My Lord, yes, and the draft order then obviously doesn't go into all these long stories. It simply captures what we need to happen. I beg leave, my Lord, to hand up a copy of the draft order.
Thank you.
And Your Lordship will see that, okay, it's deliberately silent on the question of the accused's appearance or non-appearance.
Yes.
Because that's not a matter that we need to settle, Your Lordship with. My Lord, in that, against that background, we then beg leave for this court to grant the order in terms of paragraphs 1 and 2 of the draft order, my Lord, and maybe mark it X. And Your Lordship doesn't have to inscribe this, but we will then administratively deal with the issue of the case number.
Yes.
Once it's resolved. As court pleases, unless Your Lordship has any other questions of clarification, that is our prayer, my Lord.
Thank you, Mr. Moore.
As court pleases, my Lord. We are indebted to the court.
Yes, the court makes an order in this matter in terms of a document which the court has endorsed as X. It is not necessary for me to read the order. I've endorsed it and signed the order. I hand down the order.
As it pleases the court, my Lord, we are indebted to the court. My Lord, if I may just make something clear, it doesn't affect the order.
Yes.
My Lord, when I was introducing
the order says that the matter would be postponed to 26th of May 2023.
26th of May, yes, my Lord, that's correct. Now, I just wanted to put something in perspective, my Lord, when I was introducing the parties. Because again, we all know private prosecutions are rare, so that's why there are always these administrative hiccups like we had this morning.
Yes.
My Lord, we are not the private prosecutors. The private prosecutor is former President Zuma. We are simply his representatives, and that is why it is his presence, actually not ours, that is important here as the private prosecutor. So in terms of our law, he is the private prosecutor against the accused person, and he's entitled obviously to find anyone who's legally trained to represent him. So it's not a formality that we say we appear on behalf of the private prosecutor. He is appearing.
Yes.
That's good.
Thank you.
My Lord, my learned junior has pointed, oh yes, the correct case number is 2022/059772. 2022-0510/772. And that, my lord, you'll see in the court order that was issued on Monday, it's reflected in paragraph 2 of that court order,
Thank you.
where it says the case number, that's the same case number. So at least that case number has been retained. Malona Junior, my lord, was saying, for the sake of the record, the date should be explained, but I think your lordship has done that. Or rather, the date should be voiced out. It was my impression
26th of May.
26th of May.
That is,
As court pleases, my lord.
that is postponed to. Anything else?
Not on our side, my lord. We are indebted to the court.
Right. Thank you, everybody.
As court pleases.
Just one thing I want to say. I wasn't told about today's appearance, not that anybody needed to inform me. But as you would note, that there's no ventilation in this court. There's no aircon, there's no windows you can open, and COVID is still rife. So I say this not because I want to be, I say this in the public interest.
Yes, my lord.
The public gallery is going to be full. They had in the US the Golden Globes, and I believe many of the people who attended to it are now infected.
Correct.
So I say this specifically to the court orderlies. They are in charge of this courtroom, and they must see to it that they ensure that the COVID protocols are observed.
Correct.
The last thing we want is for people who have attended this court, I don't care who it might be, to get sick.
As court pleases, my lord.
Because even, I was just told that even the press, just this morning, they're supposed to notify the judge. After you came to see me, I was given a letter. People seem to don't follow the protocols here.
Unacceptable, my lord.
I mean, look at this. This makes a mockery of, what do we call this? Where you go to spread out. What is it?
Social
distancing.
Social
Yes.
distancing.
It
my
makes a mockery of it.
lord. Yes, my lord.
Thank you very much, everybody. The
We are
court will
indebted to
adjourn.
your lordship.